We are now live. Maybe in about 30 seconds, you can start, Raj and Vyapak.
Thanks. Good morning, good afternoon, and good evening, wherever you may be. My name is Raj Panchmatia, and I am a co-convener of Indian Arbitration Forum. I would like to extend a very warm welcome to our audience in India and around the world to launch of our IAF Protocol on virtual hearing by Justice Indu Malhotra. Justice Indu Malhotra is a judge of the Honorable Supreme Court of India. We are extremely grateful to her for agreeing to review the protocol and to attend the launch of the IAF protocol. Justice Malhotra is the second woman to be designated as a senior advocate by Supreme Court of India and first woman lawyer to be directly appointed as a judge to the Supreme Court of India from the bar in April 2018. She's the seventh woman to be a judge of the Supreme Court. As we all know, she has also authored a commentary on the law and practice of arbitration and conciliation, which we all refer to regularly. She has been a great supporter for IAF. Thank you, Justice Indu Malhotra, for joining us today. Before I proceed further, I just wanted to let everyone know what is the format for today's webinar. The webinar will start with an introduction to the IAF protocol and the process followed in preparing the protocol. It will be followed by the keynote address by Justice Indu Malhotra and launch of the protocol by her. Followed by a vote of thanks for launch of the protocol by Vyapak Desai, and a panel discussion on do's and don'ts of virtual hearing with our distinguished panelists and members of IAF, Mr. Renu Parekh, Mr. Naresh Thakker, Ms. Poornima Hatti, and Mr. Divyakant Lahoti. If you do have any questions for our panelists, please submit them using the facility provided in the web portal. Our panelists will attempt to answer as many questions as possible at the end of the discussion and on time permitting. Recording of today's webinar and the IAF protocol will be emailed to all of you after the webinar. All of us are working from home and joining this webinar from separate locations. Although we endeavor to bring you the best possible experience, there is possibility of technical issues and severe service interruptions. I would now want to give you a brief background about the IAF protocol. As we all know, today, technology has become an inseparable addition to the law and practice of dispute resolution. Information and communication technology are being used across the world to reform the conventional process of dispute resolution. Over the last decade, technology has brought about many changes in the field of arbitration. Some instances where information and communication technologies are being extensively used in arbitration include email-based communication between parties and the arbitral tribunal, sharing of soft copies of documents and pleadings, and conduct of procedural hearings through video conferencing platforms. The COVID-19 pandemic has made the legal fraternity realize the importance and necessity of incorporating the use of information and communication technologies in the day-to-day functioning of the courts and arbitral tribunals. The use of such technology, not just at the time of current pandemic, but in general, has immense advantage and benefit. In international arbitrations, as well as in the domestic arbitrations, the use of video conferencing technologies can using them in the arbitration can be incredibly beneficial in time and cost efficiencies and savings. The purpose of IAF protocol on virtual hearing in arbitration is to provide to parties, counsel, and arbitrators a uniform, fair, and efficient procedure for conduct of virtual hearing for arbitrations. It has been drafted in a manner which makes it compliant with all basic statutory and regulatory requirements. It provides for adequate measures to ensure privacy and data protection, and is equipped to deal with any possible disruptions or glitches during virtual hearing. As some of you may be aware, in February of 2020, the IAF launched an updated version of its guidelines, that is IAF Best Practices Guidelines for Conduct of Arbitration 2.0. These guidelines also refer to the use of video conferencing technologies to undertake activities including case management conferences, examination of witness, and oral arguments. In furtherance of the same, IAF is now proud to launch the IAF Protocol on virtual hearing in arbitration, with a view to lay down guidelines and good practices that parties to an arbitration may choose to follow when conducting virtual hearing through video conferencing and related technologies. The IAF protocol has been prepared on the basis of research of existing international guidelines on use of technology to conduct virtual hearing in arbitration that are best suited for Indian scenario. Reference has been made to the Supreme Court Model Rules for Video Conferencing for Courts 2020, the COL Protocol on Video Conferencing in Arbitration, on International Arbitrations, the CIArb Guidelines for Witness Conferencing in International Arbitration, ICC Commission Report on Information Technology in International Arbitration, BILS Checklist on Holding Arbitration and Mediation Hearings in times of COVID-19, the Hogan-Lowell Protocol for use of technology in virtual international hearings, and pertinent judgments of various high courts and Supreme Courts of India. The draft IAF protocol was reviewed by legal luminaries such as Justice Indu Malhotra, Justice Gautam Patel, Justice Pratibha Singh, Senior Counsel Mr. K.V. Vishwanathan, Counsel Mr. Naushad Engineer, and after several rounds of review, additions and edits, the IAF protocol was formulated in its current form. Members of IAF team that drove the entire process were Raj Panchmatia, Vyapak Desai, Mustafa Motiwala, Nandini Khaitan, Lomesh Nidumuri, Vikas Mahendra, Peshwan Jangir, Kushagra Agarwal, Pradeep Nayak, Varsha Shivanguda. We are also thankful to all our conveners and members for this continued support. We are also grateful to all the organizations who are supporting this initiative. We thank ICC, SIAC, MCIA, AIAC, Bombay Bar Association, Bombay Incorporated Law Society, Incorporated Law Society of Calcutta, Advocates Association of Bangalore, Indian Merchants Chamber International Area Center, Nani Palkhiwala Arbitration Center, Society of Construction Law, BIMACC, ILSCA, CIArb for supporting the IAF protocol. We also thank our technology partners, CORD, without whom today's webinar would not have been possible. We would now request Justice Malhotra to please give her keynote address and launch the IAF protocol. Thank you.
Thank you, Raj. Good evening to all of you. I feel honored to launch the IAF protocol, which I think has been prepared with a lot of hard work and effort, several rounds of refining to come to the final protocol, which has now been which is being launched today. Given the challenges of COVID-19, travel restrictions, it has become difficult to conduct in-person hearings, whether in the court or in arbitration. The crisis has compelled all of us to consider virtual hearings as the way forward, both with respect to court hearings as also arbitration proceedings. Virtual hearings could be a transformational tool for both domestic and international arbitrations which are seated in India, even during the post-COVID-19 era. It would make the process far more expeditious and cost-effective. There is a strong impetus in India to make the use of information technology and video conferencing tools to conduct arbitration proceedings remotely. The need of the hour is to look beyond the traditional modes of conducting arbitration and innovate solutions to tackle these issues. The crisis cannot stall the dispute resolution process indefinitely. The IAF protocol provides a very comprehensive framework based on international best practices. It really shows how meticulously they have worked in drafting this entire protocol. I had an occasion to go through it at great length, and I found it to be a very exhaustive framework which commences right from the moment that parties enter into an agreement to arbitrate, right till the award is passed, touching upon every aspect of the proceedings. The IAF Protocol has laid down guidelines for holding arbitration through video conferencing. This protocol aids in the identification of Gordian knots in the conduct of an arbitral proceeding through video conferencing. It lists out the requisites and standards which are intended to serve as a guide to best practice for planning, testing, and conducting video conferences in arbitration. What I perceive to be the salient features of this protocol are that it is an elaborate guide to consider before an arbitral tribunal passes the very first procedural order. It commences from there and directs the parties to conduct the proceedings through virtual hearings. It also acts as a guide to parties before entering into the agreement, conduct their arbitration proceedings through virtual hearings. The second aspect, which is very, very important in this protocol, is it sets out a basic threshold in terms of technology that should be used by the participants of a virtual hearing and highlights certain key aspects such as measures which can be adopted to ensure that cyber security and confidentiality are maintained. The third aspect I thought which was critical was it recommends best practices which can act as a good code of conduct for all participants, whether it's the contesting parties, whether it's the counsel or the arbitrators who participate in the process through a video conferencing platform. The other aspect which I think is very key to this protocol is that it provides key points for conducting examination in chief and cross-examination of witnesses through virtual hearing. There has been a lot of reservation world over about the effectiveness of examination of witnesses through virtual hearing, but I think the IAF protocol has provided a detailed procedure to address this issue specifically. The entire process is compliant and within the framework of the law under the 1996 Act, which I intend to touch upon briefly. Now, virtual hearings, there can be three scenarios. The first is where both parties consent to the virtual hearing. In such a scenario, there would be no legal issue which really would arise. The second is that if one of the parties wants virtual hearing, the other objects, maybe for good reasons, that it's not an effective mode of dispute resolution, whether disputes are complex, there are voluminous documents, or multi-party arbitrations. There may be various reasons, or it may also be a tool to filibuster, being a respondent in the case. It can be for any reason. In such a situation, the tribunal has to view the whole dispute holistically to determine whether the dispute in a particular case can be heard virtually, either partially or entirely. And then they must carefully consider the nature of the objections which have been raised, the complexity of the dispute involved, and then take a call as to whether they should proceed with virtual hearing or not in that case. For instance, in complex construction disputes, they involve multi-parties, multi-claims, voluminous evidence. It may be difficult sometimes on a virtual platform. The third scenario is where both parties do not consent for a virtual hearing. In such a case, the tribunal would be advisable for the tribunal not to proceed with the virtual hearing, as it may have an issue at the time of recognition and enforcement of the award. So these are the three aspects which have to be kept in mind while taking a decision to proceed with a virtual hearing. Now, I'm going to spell out some of the provisions of the 96 Act to show how a virtual hearing would be encompassed by the statutory framework which is in force in India. The Act contains the requirement of giving a hearing to parties. There is no specific prohibition against holding such hearings either through means of telephonic calls, video conferencing, etc. Arbitration being a party-led process based on the principle of party autonomy, it affords sufficient flexibility to conduct arbitration as parties desire. There are various provisions in the Arbitration Act which facilitate this new virtual mode of conducting proceedings through the virtual platform. The first provision which I'll draw everyone's attention to is Section 19, subsection 2 of the 96 Act. It gives a freedom to parties to mutually decide upon the procedure for conducting the proceedings, which include virtual proceedings, and in the if there is no agreement between the parties, the arbitral tribunal has been given the power to determine the manner of conducting the proceedings under Section 19, subsection 3 of the Arbitration Act. I'll pause for a minute because there seems to have been on the screen.
We can still hear you clearly, ma'am.
Can you hear me? Okay, then
I'll
continue. So I will just recapitulate what I said last was that under Section 19(2) of the 96 Act, the Act confers freedom on parties to mutually decide upon the procedure for conducting the proceedings, which could include virtual proceedings. In the absence of an agreement between parties, the tribunal has been conferred with the power to determine the manner of conducting proceedings under Section 19(3) of the 96 Act. Section 20, subsection 3 further provides that the arbitral tribunal may meet at any place it considers appropriate for consultation amongst its members, for hearing witnesses, experts, or the parties, or for inspection of documents, goods, or other property. Another provision is, of course, Section 24, which grants the right to oral hearing to parties for both presentation of evidence and oral arguments. Traditionally, of course, oral hearings have been physical, in-person hearings. But there is nothing to preclude a hearing through a virtual platform. There is nothing at all to preclude that. However, it is important for the tribunal to ensure that all concerns relating to due process are taken care of. The most significant concern relates to the inability of a party to present its case or unequal treatment of parties, which is a mandatory provision. If there is an issue of unequal access to the use of technology and accessibility, the right to be heard should be addressed at a subsequent stage rather than given up. The non-fulfillment of the due process requirement, namely the violation of a party's right to present its case, can become a ground for challenge of the award under Section 34(2)(a)(3), which is in the case of a domestic award, or for resisting enforcement under Section 48(1)(b) of the 96 Act. Apart from these statutory, so in my view, the 1996 Act, it completely would cover hearings through a virtual platform. There is no legal impediment to the same. The other aspect which I would like to briefly touch upon are the practical issues which arise in a virtual platform mode. While it is true that most of the arbitral process can be conducted virtually, including issuance of notices for arbitration, holding case management conferences, deliberations amongst the arbitrators, parties often object to having evidentiary hearings conducted virtually. There are other issues also. For instance, the issue of confidentiality and technological interruptions, which do surface on a virtual platform. Section 19 provides that an arbitral tribunal shall not be bound by the CPC or the Evidence Act. It also provides autonomy to the parties in determining their own sets of procedures. The examination of witnesses, however, is not of much vitality in commercial disputes where the evidence is largely documents driven. However, examination and cross-examination over an online forum poses various challenges. One is confidentiality. It was not earlier in our Act. It has been introduced by the 2019 amendment by a specific provision in Section 42 capital A, which expressly mandates that the tribunal shall maintain confidentiality in all arbitral proceedings. This obligation is, however, not applicable to other participants such as witnesses, the technical support staff, tribunal assistants, secretaries, transcribers, and other persons involved in the virtual process. So this is a matter which does concern parties in a virtual platform. So therefore it is necessary for parties to choose a reliable and encrypted platform for the proceedings and consider adopting various cyber security and safety measures. For instance, use of access control video conferencing platform or software with an authentication process before permitting access. The other aspect is with respect to the tutoring of witnesses. This is a major challenge, and prompting answers from a chat box to a witness or sitting in physical proximity to the witness and readily providing them with answers would undermine the sanctity of the trial procedure as being effective. The third is the purpose of examination is to test the credibility and the strength of a witness. Analyzing the demeanor of a witness by an arbitrator or in a court plays a crucial role in gauging the credibility of the deposition. So these are some issues which are of concern apart from the connectivity issue. There may be witnesses who lack technological infrastructure, knowledge to use video conferencing, and various other glitches on a virtual platform, which cannot be forgotten and have to be addressed, and probably the solutions would evolve as we go along. India at present primarily has ad hoc arbitrations. Ad hoc arbitrators could also take resort to this IAF protocol, which has been drawn up with a great deal of care and meticulous detail in conducting arbitration proceedings. The world has changed. There is no looking back. It is only time that we adapt and acclimatize ourselves to this new mode of dispute resolution. With this, I extend my heartiest felicitations to the IAF team headed by Mr. Raj Panchmatia and Mr. Vyapak Desai and his team of persons who have put this protocol together for conduct of proceedings on a virtual platform in India. My very best wishes to all of you.
Thank you, ma'am. Ma'am, may I maybe request you to launch the protocol for us?
Yes, certainly, certainly. I've lost everyone on the screen.
Oh.
Yeah.
Okay.
Yeah.
Vyapak?
Yeah, please. Ma'am, you were saying something?
No, I was just saying that we launched the IAF protocol today for domestic arbitrations and international arbitrations which are being seated in India.
Thank you, Justice Malhotra, and thank you all the participants to join for this occasion. It has taken several months to come up with this protocol, and I think we cannot thank more Justice Malhotra for giving this evergreen support to IAF, the Indian Arbitration Forum. Ma'am was even present during our Delhi event when we discussed threadbare the 2019 amendments, and some of your responses and clarifications have gone a very long way in terms of clearing a lot of doubts as to how 2019 amendments were shaped. And now with your support, IAF has launched its protocol on conduct of virtual arbitrations. Just to give a very quick snapshot on Indian Arbitration Forum, IAF, we were founded almost in 2013 with a group of practitioners who thought arbitrations are the most important part of dispute resolution system all over the world. India is on a time when BALCO was already announced as a judgment, and there were a lot of talks going on at that point in time as to what India should do more. And what we did was a group of practitioners and people who were interested in the arbitration as a practice together to form this group with a very simple but very strong passion and commitment to bring in the best practices in the arbitration proceedings in India, and more particularly consistency across ad hoc institutional arbitration and wherever it is held, whether it is in Bombay, whether it is in Gujarat, Delhi, Indore, Chennai, Bangalore, wherever it is held. Idea was to bring in the best practices and consistency for conduct of arbitration proceedings. We brought in the first practice guidelines for conduct of arbitration proceedings, and in fact, we even launched version 2 this year in 2020. And now with COVID coming in, I think the group brought in the protocol as well as part of the initiatives by Indian Arbitration Forum. I think apart from thanking Justice Malhotra again, Justice Patel, Justice Singh, and many other people who have supported this initiative of protocol and other initiatives of IF, I should not forget the team of conveners across India, Tejas Karya, Shashank Garg, Nandini Khaitan, Vikas Mahindra, Mustafa Motiwala, Lomesh Nidimuri, of course Raj, and Mr. Prasanna, Mysore Prasanna in Bangalore. They have worked on several initiatives of IAF over a period of this 6-7 years. And we have very good support from the practitioners and the community of law firms and individual advocates looking at arbitration as a practice. We have our website, indianarbitrationforum.com, and some of our members are listed on the website. I don't want to take all the names, but most of them are very prominent law firms who have supported IAF throughout. So I urge everyone to look at the website where we have put a lot of information about this, and we will constantly keep updated people who are interested in arbitration as a practice. I think there were some questions coming up on the webinar itself as to where this protocol and guidelines would be available. We obviously will put it in public domain, but it would be also available on our website, which is indianarbitrationforum.com. And we urge everyone to participate actively in all the endeavors in terms of the IAF initiative. This is a body which ultimately engages in the best practices, and idea is to create an arbitration bar in India, which is one of the most important piece, other than of course the arbitrator community and the judiciary, which brings the best practices in the arbitrations, conduct of arbitrations in India. With that, we would again, I think, formally thank Justice Malhotra on this. Thank you for spending time. I know you have some other commitments, but we would continue this webinar with very, very interesting debate on do's and don'ts of virtual arbitrations. We have some excellent panelists sharing their practical experiences. So without spending more time on this, I invite Renu Parekh. She is a very senior practitioner in Mumbai, and she has spent a lot of time in different law firms in Mumbai as well. And she will conduct the further discussions on this webinar and introduce the other panelists. So thank you again, all the participants, and Justice Malhotra for joining. Thank you.
Thank you.
Thank you. Thank you.
Over to you, Renu.
Renu, you are on mute. You are on mute.
Okay. Thank you, Vyapak. Thank you, Justice Malhotra. And a very warm welcome to all the participants on my behalf and on behalf of all my co-directors at IAF. A very short introduction of our esteemed panelists today. Ms. Poornima Hatti leads the dispute resolution team at Samvad Partners. With nearly 18 years of experience, she acts both as a counsel and arbitrator in domestic and international arbitrations. She has lived and worked in different parts of the world, including Singapore, London, Delhi, and is currently based out of Bangalore. Our second panelist is a third-generation lawyer, Mr. Divyakant Lahoti. He has done LLM from King's College London and secured specialization in intellectual property rights from the University of South Africa and WIPO. He was acclaimed as a super lawyer in 2016 and as the shining star of Indian legal fraternity in 2019. Earlier this year, he received the award Lawyer of the Year, Alternate Dispute Resolution India from Finance Monthly, United Kingdom, and as late as last month, he was recognized as one of the top legal influencers under the age of 40 years. Divyakant is one of the leading advocates on record in New Delhi and is based out of there. Our third panelist is Mr. Naresh Thakker, who also needs no introduction. He is a partner at ALP and heads the firm's litigation and alternate dispute resolution practice. He is duly qualified both in India and England and Wales. Mr. Thakker has over 20 years of experience in litigation, mediation, domestic and international arbitration, particularly in large infrastructure projects, mergers and acquisitions, regulatory and tax disputes, and white-collar crimes. Over the years, he has handled both ad hoc and institutional arbitrations, including those under the rules of ICC, LCIA, CIAC, Intertral, and the Swiss Chamber of Commerce. So without wasting of our time, we'll start the panel discussion. And I'll pose the first question to Mr. Thakker with his such a varied exposure. Do you feel video conferencing facility should be customized for each arbitration or standard operating systems should be adopted across board? What are the criteria would you look for while choosing one?
Thank you so much, Renu. Before I start or rather delve into this topic, let me go back in point in time and let us look at this entire thing from a historical perspective. I don't know how many of us would actually remember the radio of the past or the advent of gramophone and how long it lasted. Or let's say the introduction of television in the 1970s and that of the VCR in the 1980s. How many of us truly know that the digital electronic calculating machines came about during World War II? And integrated chip technologies in the late 1950s, which actually led to microprocessor and microcomputer revolution in the 1970s. But these were never meant for you and I. What we know as and refer to as devices of our everyday use actually came about in the 2000s. And since then, they have grown at a scorching pace. When I joined the profession in 1997, I quite remember that very, very vividly, because there were no softwares at that point in time as what we have now for conducting any case law searches for that matter. I also remember that I used to sit down with heavy books, the case references, and used to look for precedents in all of that. And from there and until now, the change of pace in computing technology has been massive. Touch phone, as an example, something that we can't live without anymore, and our kids possibly know more about it than any one of us will ever know about, happened only in 2007. Now, the point that I'm trying to drive at is that the pace of development today is like what we have never witnessed ever. It is now more imperative for us to move on with times. And this is more so in the subject that we are dealing with, namely arbitration. We have had systems for video conferencing for around a while now, and I don't think while it's not been too long, but they have been around for some time. But it actually took a pandemic to teach us far more about them and the use that they can be put to than we ever would have possibly learnt in normal times. It is clear that we have to adopt technology going forward. I don't think any one of us can today be immune to it. Having said that, in my experience, the different and varying manners in which technology has been used in arbitration during the pandemic has created a situation of data overload. There is confusion galore, and quite frequently, there is loss of time in trying to navigate the technological barriers. Using, therefore, a standard operating system has its own pros and cons as I see it. I actually have had tribunals which have asked for preferred platforms to be used in different arbitrations. This has actually led to added cost of facilitating video calls on different platforms for each arbitration. Now, this is something which cannot be ignored. Secondly, one needs to be mindful of the fact that not all of us are as tech savvy, and not all of us will be able to fully understand the use of different platforms. Granted that it is time for all of us to up our game and to learn the new lingo, so to speak. But we all understand that different operating systems only result in time being spent in downloading them, and then you've got to get acclimatized to it. Thus, a standard operating system would definitely aid in saving time and cost. An added issue that one needs to bear in mind, and this is something which Justice Malhotra actually adverted to, which is confidentiality. Now, use of different technology and various platforms and tools might expose us to the threat of security breach and breach of privacy and more so of the data. One other question that one needs to bear in mind, and this is more so for practitioners, since we often do this for clients. If I, as an advocate, am hosting the third-party application, is the burden of preserving the confidentiality now on me? And the question that we all need to answer is that this is not just as an advocate, but I think all of us need to find an answer to this. Would it not be unfair to expect any stakeholder, for that matter, to bear the burden of confidentiality when using a third-party application that has actually been directed by the tribunal to be particularly brought into a particular arbitration? Thus, as I see it, having a standard operating system for all arbitration would actually assist in reducing the risk of confidentiality as well. The flip side to this, obviously, is that in each arbitration, party have different budgets, the pockets differ, cost of arbitration differs from matter to matter. Given that budgets may be higher in a given matter than the others, should parties not have the option of choosing an operating system that is best suited to their needs? Technology obviously comes at a price, and different feature-specific platforms allow the option to increase efficiency for parties who are willing to pay. One other issue in a given circumstance, it may be helpful to keep the option open for parties as the venue or location may weigh on their choice of technology. Just to give you an example, a particular platform can work very smoothly at lower bandwidth and thus may be more suitable for a remote area, than some other platform which actually requires a higher bandwidth. Then again, in cross-border arbitrations, this issue becomes more acute and pronounced. It then becomes necessary to consider which platforms are accessible, as well as the familiarity of the tribunal and the opposing parties to the respective platforms. And I can give you an example. In Dubai, for example, there are restrictions on several video-based applications. So you've got to be very careful when choosing a particular platform. Thus, as I see, while it is desirable to move to a standard operating software, it is easier said than done. But then again, as I mentioned at the beginning, I think that the pace of change has been scorching, and I'm sure in a very, very short time, we will witness birth of such a standard operating software suited to the disputes in particular, which will eventually be recognized and used worldwide. And that truly will make disputes global as I see it.
Renu, you're on mute.
Thank you. So this will lead to special storage of recordings and data, technical assistance, etc. Mr. Lahoti, in your opinion, do you think this process will become more cumbersome or it will ease out the process in the long run?
Well, first of all, I agree with Naresh that we have to be very conscious of choosing which software to use, because even in our judiciary, where different high courts are using different softwares, like Delhi High Court using Cisco WebEx. I appeared before Andhra Pradesh High Court where they are using Jitsi and Blue Jeans, something like that. Now, coming back to this topic, interestingly, our own IAF protocol deals with this issue of storage under clause 2E and 2F of the protocol. Although the transition has been challenging on various aspects, but in my opinion, the road ahead will only freeze out these technological hiccups. Such transition can be simplified by approaching arbitral institutions, which will provide you the infrastructure required for proceeding management of the online proceedings. The institutions are equipped with solutions for smooth conduct of arbitral proceedings, such as technical assistance, their employees are there, data storage, data protection with end-to-end encryption facilities for the recording of arbitral proceedings. Employing technical assistance, particularly, and adopting the IAF protocol in the procedural order will ease the transition from physical to virtual, and it will provide a roadmap for the stakeholders. Now, so far as technical assistance are concerned, because Renu, you asked me this question, will provide support to the arbitrators and parties in organizing and conducting arbitral proceedings, so that the proceedings are conducted smoothly without any technological outages. Clause 2E, in fact, if I remember correctly, of the IAF protocol envisages the role of technical assistant to assist the parties in arbitral tribunal in setting up the video conferencing instruments and connectivity. The resolution of technical issues arises while conducting the virtual hearings. An important aspect which should be ascertained by all the parties to the arbitration, with Justice Malhotra and Naresh also touched, is the confidentiality issue. I am of the view that the arbitral tribunal should also obtain a declaration from these technical assistants to keep the matters confidential which are arising in these arbitral proceedings. Now, so far as coming to the other part of the question in respect of recording of proceedings, the same should be done only after approval of both the parties which are involved in the arbitral proceedings. Appropriate procedural order should be passed so that these recordings become part of the arbitral record. Just like Justice Malhotra indicated, section 34 to 8.3, that if the party is not given an effective hearing before the arbitral tribunal, it could be a ground for challenge of the arbitral award. So therefore, we need to make arrangements for appropriate technology to be in place before we proceed with the arbitration. Many institutions are, in fact, well equipped, and are responsible for ensuring that all proceedings are recorded properly and they are stored securely at a particular destination so that it can be retrieved at a particular point of time whenever it is required. And these recordings are also shared with the parties and with the tribunals and other stakeholders. It should be ensured that no party should record the arbitral proceedings without the prior approval of the arbitral tribunal, and more so with the consent of the opposing party. So these are my broad views on the issue which you raised, Renu.
Thank you. Poornima, do you feel the reconciling arbitrators' diaries to also reconciling time zones, are we adding some more woes to the litigants, or are we going to again ease out the process?
Thank you, Renu. Let me start by saying it's an absolute privilege to be part of this conversation, and congratulations to IAF on this virtual protocol. I don't agree. I think we've all somehow managed to run arbitrations despite being on different continents. I think without having to travel outside our time zones, there will definitely be an increase in efficiency. And the root of sort of, at least in India, in terms of why arbitration has become more popular, is always because it is definitely considered more efficient, no longer cost effective, but at least efficient compared to our existing court litigation. So I think arbitrators, as well as litigants, as well as the arbitration bar, has commendably adapted to working under these new circumstances. And I think we can work around, and virtual arbitrations are truly here to stay. And I think they will make a difference both in terms of cost as well as time. Thank you.
Thank you. Mr. Thakker, prior to the commencement of the virtual hearings, what kind of preparations you will look for?
Naresh, I think you are also on mute.
Thanks, Poornima. Sorry.
Yeah.
So this is, this is where I think this is the best example of what technology can do to you. But, so the question that you've put to me, I think, by what happened right now, that's just an inkling of what is likely to happen also during your arbitration. But let me just give you a sense of what exactly I would look for, because this is how I, having done all these matters both in court as well as in arbitration, this is what I have gathered from my experience. The first and foremost thing that you need to do is to explain to your client the benefits and the risks which are involved in the new format of virtual hearing. And this is important because, it is quite one thing to say that I will conduct a virtual hearing in a hearing in a virtual space. And it's quite different when you actually sit down and do the hearings. And all of us who have actually appeared either in courts or have done arbitrations virtually have actually found that, there are lots of difficulties. You can't understand, the demeanor of the judge. You're not able to, gauge fully as you would otherwise be able to do in an open environment in a physical court, the mood of the judge. So I think, it's very important for people to understand, for your clients to understand what are the benefits and the risks that are involved in the new format of virtual hearing. Important for all stakeholders before actually the hearing commences. It is very, very important for all stakeholders to conduct a full trial run of the system that is going to be used. And this should be done well before the hearing. All persons, including the witnesses, need to be properly identified, and this should happen during the trial run so that each side as well as the tribunal is familiar with all the personalities who are involved. During such test runs, all persons, including the tribunal, actually needs to be made aware of the features of the system that is being used, and everyone ought to familiarize themselves with it. I can tell you personally, I've been in matters where I've seen huge embarrassments caused to the advocates and the parties involved, where during the middle of the hearing, the advocate started talking with his client, and he was actually seeking some instruction, and he forgot to put himself on mute, which is exactly the opposite of what happened with me when you asked the question, that I was on mute and I did not, think about putting unmuting myself. And then similarly, I had a situation where the tribunal members forgot to mute themselves when they were speaking amongst themselves. So these are issues that, can be sorted out if you have familiarized yourself with the system well enough and quite, in the beginning. Next, that I think is that the party should have all the necessary documents readily accessible, and there should be a agreed marking of all these documents. So, thus everyone is following the same system, everyone is following the same markings, quite the same as what you would have in a physical hearing. If transcription services are being used, it is important for the transcriber to actually also be present during the test session. And one other thing which is quite important to my mind is for the parties actually to consider having a virtual breakout room, including maybe a teleconference line or separate virtual meeting space, which is completely separate from the main proceeding. And this can be used for all the privileged conversations that you may want to have with your client. And this is exactly to, iron out the issues about the embarrassments which are otherwise caused in such hearings. Consider also whether all parties are going to use their own offline copies of material or whether a secure cloud-based server will be used to upload material, or maybe, even the shared screen. This, to my mind, are the important and the key elements which, one needs to look at. One other thing which I must, mention, and this is never the last and never the least, which is that you must have a technical assistant on the standby, because, technology can fail you at any given point in time, and you would do best to have someone to assist you at the very first instance, rather than running helter-skelter looking for an alternative at a later point in time.
Renu, if I may just weigh in
Sure.
and make one additional point. I mean, I cannot stress the whole breakout room aspect. I think we've all had situations, particularly because of the pandemic, we've had teams sitting in different parts of the country. Sometimes you're arguing before a court, which is in a third part of the country. Your senior counsel may be from somewhere else. So there is that real actual arbitration hearing or court experience where you're allowed to actually tap somebody on the shoulder, pass the note, pass the judgment. That is not so easily accessible if you're just working through one dominant system. So the breakout rooms or perhaps another screen, this is something that one must accept and understand. And of course, virtual hearings are here to stay beyond the pandemic. So if you think you're comfortable to have a team in one place, well, plan it in advance so that, last minute instructions or, how you communicate instructions to counsel, or how are you going to get inputs from your team, all of this needs to be thought through as well.
So
and if I may add,
sure.
Sorry, Renu, if I may also add, one more thing that I believe that given what we are facing now and the sort of situation that we are in, obviously we need to move on with life. And as Justice Malhotra also pointed out, that crisis cannot stall the justice delivery system. But at the same time, to me, maybe call me old school, but I find the entire advocacy through a screen a little unsettling and maybe even a little intimidating. Having done so much of hearing in a live atmosphere, in a live environment, I believe that, that is the best mode in which you will ultimately be able to deliver the right kind of product for your client. And to me, actually, the thrill of a courtroom, a thrill of an open courtroom environment is great. It gets my adrenaline running, and I know what I'm doing. I'm in control of things myself. But I think in a virtual environment, and there's a huge plus in a virtual environment as well, because I have seen many people who are not comfortable in an open courtroom setting, and they now are doing fabulously in the virtual setting. It does have its own pluses, and how the entire thing is actually set up and how comfortable you become with the system is far more important actually than anything else. So if you're very comfortable with the system, if you're comfortable with the environment around you, you will be able to do a great job.
Okay, thank you. Mr. Lahoti, would you like to add something to this?
I think one of the issues which Mr. Thakker touched about, and also Poornima, regarding what will happen when you are arguing a matter and you want to seek an instruction from the client, or if a senior is arguing and you want to give him some instructions while the arguments are still on. So that's the concept of breakout rooms are there. However, many times we face difficulties in giving instantaneous instructions to the senior counsels. For that, we usually do a separate WhatsApp call while the hearing is going on. So we plug AirPods or earphones on and connect with the senior counsel so that we can give him instructions so that for this purpose we have to make this argument, something like that. So yes, there are challenges which are not there otherwise if you are there in the open courtrooms or physical courtrooms.
And in the same line, do you feel preparations also required, special preparations are required when a witness is being cross-examined? And I think we can take one of the poll questions here on the witness examination.
So, Renu,
sure, Renu. I'll launch the poll and we'll get you the results in a few minutes. Thank you.
Yeah, so I think the participants have about 60 seconds to vote. Yeah, please continue.
So was that question for me or was it for Divyakant?
I think both of them, you can take turn by turn and address as you.
So yeah, Divyakant, please go ahead and then I can proceed.
Yeah, actually there is another issue which is quite important. What Renu has just talked about is whether these virtual hearings are actually cost effective or time effective. We need to understand that aspect very clearly while we adopt these technological advancements. When we went to ADR system, we thought that it is cost effective. But when I look at virtual hearings and virtual proceedings, I think, and it's my personal opinion, they are indeed further cost effective. These technological advancement in the field of law, especially in the last 4-5 months or maybe 6 months, have been phenomenal. Legal technological changes are not new to our fraternity, but this outbreak of coronavirus has become a catalyst of change in our system. With time, the senior colleagues have embraced the technology and the younger members are getting more opportunity to appear and argue across various forums, both domestically and internationally. The virtual hearings have become, to a large extent, a new normal, which we usually call it. In fact, I was attending one of the Supreme Court hearings where our Supreme Court has interestingly observed that hearings on video conferencing can be said to be equivalent to in-person hearings, as one can hear and observe the parties if they were in the same room. Now, I would also request the attendees to answer this poll question, whether they think whether virtual hearings in arbitration are actually time and cost effective. So, because if you can also put that poll question in the chat box so that our attendees can answer that question.
Done, Divyakant.
Okay, thank you so much. So till the time that answer is coming, I'll come back to Vikas again to you. But I think this new normal of virtual hearing is cost as well as time effective. Virtual hearings save not just overhead expenses but also time invested in arbitral proceedings, especially in tier 1 cities like Delhi, Mumbai, Bangalore, Chennai, where travel time is a huge factor. More than 2 or 3 hours a day are saved by adopting these virtual hearings, which were earlier spent in commutation and in traffic jams. Same is also true for international arbitrations for more than one reason, and all of you can guess why. Apart from the time which is saved, there is huge difference in financial cost involved in the physical hearing and virtual hearing. Even though the arbitration was supposed to be cost-effective method of dispute resolution, but with time, it has started to cost more. And thankfully for this virtual arbitration and virtual hearings, various costs are down, which will create a huge difference in the financials involved. At the top of my head, some of the major costs which are cut down would entail booking of venues for arbitration, travel and stay arrangement for arbitrators, counsels for the parties and the parties themselves. which is a huge cost saving, because usually these arbitrations are done either at some of the hotels, 5-star hotels, or some ad hoc arbitration centers. The use of technology, not just at the time of current pandemic or any other such emergency situation, but in general, has immense advantages and benefits. In my humble opinion, the use of video conferencing system to conduct hearings has resulted in incredible benefits in terms of time efficiency and cost savings. So these are my preliminary views, Renu, on this aspect.
Mr. Thakker, you can share your views.
So, Renu, should I go back to the question that you have actually asked on the poll, on the poll regarding,
the preparation
witness
for Yes.
Yeah, the preparation for a witness cross-examination.
Naresh, if you want, I can just pull out the results of that poll before you start.
Yes, it'll be great. Yeah, absolutely. It'll be great.
So we have 14% saying yes in all cases. Youth 71% saying yes, but only in some cases. And 14% also voting for maybe. So virtually everybody has agreed for this.
Yes, that's a
very positive.
Says something. Yeah, very positive. Very positive. But then again, we've got to remember. I think personally, if one was to ask my view, having I have done quite a few cross-examinations through the pandemic, and let me just give you examples, 2 different examples. One where it was a shareholder agreement, and the other where it was a construction project. Shareholder agreement, less voluminous documents, lesser number of pleadings, not too many legal issues actually to go through. And because the documents were less, the correspondence was less, it was far easier to conduct the cross-examination. And I will come back to the protocol a little later, but let me just put forth what I believe is the way forward when you conduct a cross-examination in an arbitration, and where you should and where you shouldn't. But when that was my experience, therefore, vis-a-vis a shareholders dispute. When I did the cross-examination in the construction dispute, it was a different ballgame altogether, entirely different. And I must say that my experience there, again, it's an international arbitration seated in India. We have Indian arbitrators there. No transcribing facility was available. The client did not agree. My client being someone who's seated outside India, and yet did not agree to the transcribing facility. So we had one of the stenos called in, and the steno was actually taking down the questions and then taking down the answers. There was whole lot of confusion. I would ask a witness certain question, the tribunal would try and put that question in their own words, and I don't know why they did that. And that's something which happens in Indian arbitrations quite often, that the tribunal actually tries to then put your question in their words to the witness. Then the witness would give an answer, and the tribunal would try and dictate that in their own words. And the person who was typing was typing something entirely different. And this is happening when we are looking at thousands and thousands of pages of documents. Trust me, it is not easy. Trust me, it is not great. It's not a great experience. And you would actually, in that scenario, want to move your cross-examination of witnesses into a physical world. And here is what I believe, what people should do. We all understand as lawyers that there are certain key witnesses. All witnesses are not important. It is only certain key witnesses who are more important to the case. And as practicing lawyers, as practicing advocates who do representation work, we all realize who are the key witnesses. And then you'll have certain expert witnesses who may become key witnesses for you. Those people are the ones that you should move into physical hearing. The rest can actually remain in the virtual world, and you can conduct the cross-examination virtually. And I can tell you that, in a construction arbitration, and the one that I'm running, we have 9 witnesses So 5 on the other side and 4 on this side. So you can imagine the confusion that is being created. If you have so many witnesses, how do you deal with them? So if you can move a key witness into a physical hearing space, and the balance, if they can be conducted. So let's say we have only 2 key witnesses, we move them into the virtual space, the balance are taken into or the physical space, and the balance are taken into the virtual space. My own belief is that the hearing would go on smoothly, and then you can maybe do the final hearing if you want in the physical space, because many people would actually prefer to have the final hearing in the physical space, because then you can, objections are easier, taking instructions from your own junior is easier, understanding the demeanor of the judges is easier. So now coming back to the protocol of a cross-examination, Justice Malhotra actually referred to 2 very important things, and I must touch upon that. One is tutoring of witnesses and the demeanor of witness. Tutoring of witness, I must say, is something which is rampant. I have seen it happen in many of my matters, and especially if now witnesses are going to sit away from you, the witnesses are not in front of you, I think it becomes extremely important for the tribunal to actually give proper instructions on how the witness is to be placed. The fact that you should be able to see the witness's head, from his head all the way up to his torso, is extremely important. The fact that not just that you're able to visibly see the witness, but the fact that you have a camera behind him, such that you can see the entirety of the room, extremely important. Let me give you an example. Many of us who have actually sat for the SAT exams would actually realize that virtually, when you sit for the SAT exams, they actually ask you to sit in a room which where you have nothing. Your phones are not supposed to be with you. Then they would ask you to take the camera, and they would ask you to pan the entire room to ensure that there is no one else present and that you don't have any other device with you. All of this is a extremely important feature of cross-examination of a witness. Then again, in ensuring that the witness has all the records, especially his or her affidavit, and that it's an unmarked copy of the document which is actually given to them. Like I said, all devices, namely the iPad, the phones, the iPads, any other computer, actually ought not to be allowed. Further, instructions can be given by the tribunal. So many times what happens is that as a lawyer, you would want to confront the witness with a document. It is important that the document is actually sent to the tribunal way in advance. You don't need to, obviously, you're going to confront the witness with the document. You don't need to give the witness the document, neither the opposite party the document. But at the time of the hearing, it's important that you share the screen such that the document is available for everyone to see. More importantly, the tribunal, the witness, and the opposite party. And again, the last thing on this is that wherever the witness is seated, it is important to check that the remote venue is adequately lit, has proper acoustic, has good connection. Again, from my own experience, I can tell you, I've had a witness examination which has happened. Witness is sitting remotely in a virtual space, and with extremely poor lighting, not that great acoustic. I couldn't hear what the witness was saying. I couldn't see what the witness was doing, for a large part. And I kept on telling the tribunal that, I believe, everything is not great as what I see, but the tribunal didn't actually agree with me. And I had my own doubts about what was going on in that matter, but, that's a separate issue altogether. So this, to my mind, is what I believe ought to be the protocol. And the protocol, now what has been brought out in the IAF protocol, it is superb. I think it takes care of a lot of things that I have spoken about. Sorry, Renu, I think you are on mute.
You're on mute.
Yeah. So, Vikas, do we have the results for the second poll?
Yes, we do.
Yeah. Can you share that?
I think the attendees also agree that virtual hearings are cost effective and time effective. So far as no is concerned, there is hardly any.
Yeah.
Some people are still not decisive whether it would be cost effective or not.
So, Poornima, the obvious next question is, going forward, what are the kind of points would you look forward to record in an arbitration agreement?
Renu, I think that's a very important question. And I think a lot of us are thinking about it consciously. And this is not only about future agreements. I think even contracts that have already signed, it's worth revisiting them if you want to put in a virtual dispute resolution clause and consider. Points have been made about complex contracts and whether some will suit virtual arbitrations and some may not suit. But I've had clients who have had large pharma companies who may be on the other side, have vendors who may be very small players. So arbitrations can be of any kind. They can be small, low value arbitrations. They can be extremely high value, multi-jurisdictional, multi-party arbitrations. So it's worth looking at each arbitration agreement or each arbitration set to see whether virtual hearings will now fit the bill. I think there's an enormous and very exciting ecosphere right now in India. Number of startups who are helping, showcase arbitration virtually with their own panel, their own platform, document sharing details. Now with the IAF protocol also. There's much that can be done for a certain kind of arbitration. So it's definitely worth revisiting to see if you write in those. And I think if you write consciously where everybody is still happy together before disputes arise, I think less chances are that they will be challenged on this ground. Something that's definitely worth looking at.
So you're suggesting that we should incorporate in the arbitration agreements the kind of platforms you're looking at, the number of virtual hearings or the kind of witness examination, everything should be identified and recorded?
Start with, we should just say whether you're open to a virtual hearing or not, right? And I mean, you can then make a reference to the protocol right now. If you make a reference to an IAF protocol, all of which was there in the IAF protocol automatically is part of the protocol. I do think personally that you should go into details of, what platform you want to use or whether you want to specifically look at witnesses or all of that. But I think if you're looking at documents only, and if that works, we'll say that. But a cross-reference, and there are now many protocols, almost all international arbitration institutions have their own protocols. Supreme Court, for instance, has their own protocol. It's been sole protocol that has been in existence much before the pandemic. So there are a number of protocols which can be made references and put in there. If disputes have already arisen, I think in that context, it's worth having a procedural meeting, and the protocol refers to that, so that parties can come together to say they're happy to go ahead with this. I'm conscious of time, Renu, so I'm not going to go into detail, and I know you may have to do other.
No, that's fine. You can continue.
So yeah, that's really what I want to say.
So, both you feel that the virtual hearings is more adaptable for small claims rather than large voluminous claims?
I think both can work, but small claims most definitely so. I think there's going to be less objections. The conversation just now with where we said that in large construction claims, it's difficult to see the witness demeanor, issues of high volume documents. But that may not be the case with low claims and low value arbitration. At least that we should start the process of reviewing that. And I think that they can work.
Okay, thank you. So, as a correlative above also, Poornima, what are your views? Do you think law schools will need to expand their horizons and include all this in their curriculum, or what do you?
I think as Naresh said right at the beginning, the younger generation's far more tuned into technology. They're up to speed, and I think they know and they understand what is happening. So I don't think there is a need for a separate course, but I think it would worthwhile to have a moot maybe to see whether this is something that, a virtual arbitration works. I think an exam question on whether there could be a challenge to an arbitration just because it was held virtually. And there have now been debates, entirely, even, world over on whether rule of law is upheld through arbitration. So I think these kind of questions work. The idea that online arbitration or online dispute resolution is really now part of our lives. It's something that can be discussed, should be discussed, so that it becomes part of the curriculum. Thank you.
Yeah, because we can
Renu,
also take the last poll.
Sorry, Renu, I just wanted to add something to
Sure.
what Poornima just mentioned. I think personally, my belief is that it is the generation that is right now talking, and maybe the generation above that which needs far more training. And that apart, I think one thing that we must bear in mind, sitting in Mumbai and Delhi, we fail to understand that Mumbai and Delhi does not encompass India. India, as we understand, is built up of many places, remote areas, places where people don't have the sort of access that you and I have to technology. And also that people don't understand technology. You go to the Mofussil courts and you will suddenly realize that the judges there don't understand technology, the lawyers there don't understand technology, and that apart they don't have access to the sort of smart devices that you and I have. I think these are the places where maybe and I don't know where the answer lies and who should be doing it. Maybe the Bar Council needs to do it proactively. Maybe we as firms need to step in to actually educate people in these areas such that we can bring them up to speed, and we need to do that in a hurry, because if those courts have to match up to what a high court in a given area and the Supreme Court can do, then you really need the education to be imparted to those courts and the advocates and the judges in those courts. Without that, to my mind, the judiciary will truly stutter, and the arbitration in this country will also suffer on that account, because a lot of your domestic, in fact, almost all of your domestic arbitral awards in a 34 will ultimately land up in one of these courts. What are you going to do? If these guys don't understand, if the lawyer there does not understand, or if the judge there does not understand technology. So I think the training that we are talking about, yes, to my mind, it is now an imperative that in the law schools the training ought to be imparted, because that is the way forward. But I think we need to step back and educate people, the current lot far more, so that we can bridge the gap, so to speak.
Okay, Vikas, can we take the third poll as well? Vikas?
Yes.
Yeah. Okay.
It's already been launched. Thank you.
Okay. And as a Mr. Lahoti, just based on what we are discussing, how do you envisage the role of institutions in the future? So will they shift from being a facilitator also to the law, being a watchdog?
Well, I think this question is subjective to the rules and regulations of various arbitration institutions. The parties may jointly agree to pursue arbitration institutionally. In such proceeding, the institution rules will govern the arbitral proceedings. These rules empower the institution, and these rules will decide whether the role of institution shall be that of a facilitator or that of a regulator. However, so far as watchdog is concerned, what it means is its power to regulate. Now, the role of institution shall be determined by what parties agree amongst themselves and what the rules of arbitration institution envisage. However, to my mind, the recent 2019 amendments in the Arbitration and Conciliation Act, a new Part 1A has been inserted for the establishment of Arbitration Council of India. Now, although such amendment has not yet come in force, however, the duties and the functions which have been entrusted to the Arbitration Council of India are not less than that of a statutory watchdog over these arbitration institutions, as well as the matters related to arbitration. In fact, Section 43D, if I remember correctly, gives a roadmap to the Council to perform elaborate functions for augmenting arbitration culture in India and its standards, and to maintain its standards in India. So that's my view.
Okay.
So far as watchdog concept is concerned.
So, Vikas, do we have the poll results? I think is lost. Okay, let me put another one question to all the panelists. What would you look for in an award to challenge because it was conducted partially or entirely virtually? We can start with Poornima sharing her thoughts.
Thank you, Renu. I think this is an area that will see a lot of litigation going forward, and it'll be interesting to see how that shapes up. I think I would look for whether parties have consented to the online arbitration process, and I think that is the route. If parties have not consented, the protocol, for instance, clearly says if there is no consent to the online process, there should be a reasoned procedural order recording the objections, as well as understanding what those objections are and, if possible, trying to address those objections by a party. I think this in itself, if it's met, just because an arbitration is conducted online, I don't see any problem with that. In fact, we now have courts in India that are actually enforcing arbitrations, arbitral awards that have been conducted entirely through the virtual process. So if you've participated and consented and you've gone through the whole motions, just because of the virtual process, I think it will be difficult to cross the high bar of an arbitral appeal. That's my opinion. Thank you.
Mr. Thakker, would you like to add anything to that?
Yeah. So this is, let me go back to a question in this regard that you'd asked, Poornima, on the reconciling of arbitrators' diaries and reconciling time zones. My personal belief is that, that is one area, which poses a huge challenge in case of a virtual hearing, because, you can imagine you're sitting here, your opposite side is sitting somewhere in let's say, US, and you have arbitrators sitting elsewhere. So yes, to my mind, reconciling the diaries not just of the arbitrators but now of the parties and the witnesses and whoever else that you may have is going to become that much more difficult. One of the issues there, and this is where the challenge could possibly lie in a 34 as I see it. I mean, obviously there will not be a 34 in an international commercial arbitration unless it is seated in India. But at the same time, what we must bear in mind is that a arbitral tribunal has to evenly handle both sides. So it is going to cause when you are looking at different time zones, you are looking at inconvenience being caused to different parties who are based across different time zones. It is important, and this is where I think the issue would be, that it is important for an arbitral tribunal to ensure that the inconvenience is distributed evenly across parties, because as we understand, equality of parties in an arbitration is extremely important. And the challenge really would be that if the arbitrators, from an arbitrator's perspective, if he or she or they are not able to ensure that one party, that no one party is actually prejudiced in terms of inconvenience caused, and that it is actually distributed evenly amongst all stakeholders. If not, then you can take it that you will have challenge. And I don't know how it will be handled in India, a challenge of this kind, but I can quite imagine if you were sitting in one of the jurisdictions, namely, England or any such jurisdiction which is, far forward looking, they would have a view about this. And it is quite a possibility that, challenge of this kind will be looked at quite, with an open mind and an open eye.
Thank you. Vikas, do we have the poll results? Yeah, so going forward, how would you like, how likely are you to use virtual hearings in your arbitration? And we have 60% saying yes, more than 50%. So that's another very reassuring answer. And the rest saying up to 50%.
I just want to add on this particular aspect. So far as virtual proceedings are concerned, what Poornima and Naresh indicated had another aspect to it. Now, so far as challenge is concerned, so section 34(2) Roman 3 says that if the parties is unable to present his case, then it's a good ground for challenge of an arbitral award. Now, the question is, what do you mean in these proceedings, a virtual proceeding? What would be the inability? Now, the inability could be technological inability. the accessibility issues. Now, different time zones. For example, I was doing an international arbitration under the aegis of Hong Kong International Arbitration Center, where the arbitrator was in South Korea. We were in India. One of our party was in Hong Kong, and another, the main claimant, was in US. And the time zones and the time for arbitral proceedings was a big issue. What time should the arbitration start and what time should it end? Whether we were given effective time to make a final arguments during that period of time, because in one zone it would be day, in another zone it would be night. So there was a lot of inconsistencies and a lot of friction between the parties of choosing a particular time for arbitration and making their submissions. So that is one aspect so far as big arbitrations and international commercial arbitrations are concerned. Now, looking from a domestic point of view, for example, if a lawyer is there in a remote area, for example, somewhere in Madhya Pradesh, say Guna, who doesn't have accessibility to a good internet connectivity or does not have good softwares and technology to communicate in an arbitration proceedings, and he has requested arbitral tribunal. So sorry, I cannot do arbitration virtually because I do not have these systems available where I can present my case effectively. So that could be another area of challenge, that even despite his inability to present, yet the arbitral tribunal proceeded with virtual proceedings. This one party may have all the access, another party may not have that much of access. So that is a consideration that we have to see. And the tribunal has to balance these inconsistencies and decide whether they want to continue with the virtual hearings or not. And if they decide that they want to do virtual hearings, then that must be recorded with the consent of both the parties in the procedural order of the arbitral tribunal.
Okay, thank you. I think we are going to run out of time, so I'll take one very quick question from the participants. The question is on the aspect of data preservation. Over a period of time, the software and technology is updated and changed. It may happen that the recorded hearings may not run in the new adopted software. So how do you resolve this? Any panelists can take this up, or maybe even Vikas can help in answering.
I think that there is enough technology now to make sure that you're able to keep and preserve data across. I mean, we figured out how to move from floppy disks to CD drives, and we no longer use CD drives. So I think there will always be a transitional technology, and just the number of startups in legal tech in India, it's absolutely bursting. So I don't think that will ever be a challenge in terms of data preservation. I think the issues of confidentiality that have been discussed in terms of data transition and maintenance of data with others, including with the tribunal, that will always be a concern depending on how much we spend on that. But if money is not an issue, I think this will not be a concern. Those are my observations.
Okay, thank you. I think we've run out of time, so I'm going to quickly ask every panelist to either say yes or no for going forward for virtual hearings, starting with you, Poornima, yes or no?
Yes, thank you.
Divyakant?
Definite yes. I've been doing it, and yes, I'm going to take this forward.
And Mr. Thakker?
Yes, and I have my reservations about it as well. As I said, it's never going to be an easy answer. I don't think every matter deserves a virtual hearing. There are matters which do deserve physical hearing. And then, as I said, I mean, in a matter like a construction arbitration, you can have core hearing shifted to physical space. Everything else can be virtual.
So thank you. We have a mixed view here, but virtual hearings have come to stay. They might have originated under pandemic, but as they've come to stay, not merely as a reminder of changing times, but also indicative of a world fast moving towards the technology enabled and a more seamless and borderless means of communication. So with that, on behalf of Indian Arbitration Forum, I will thank all the panelists, all our supporting organizations, and Vikas particularly. Thank you.
Thank you. It's been a pleasure.
Thank you, Renu.
So
and for
much.
the participants who had asked for the IAF protocol, a link to the IAF protocol is available on the chat window, so please access it from there. Thank you, everyone.
Thank you.
Thank you so much.
Thank you.
Thank you.